Supreme Court just did something that changes gun laws in every single state in America. Not just some states, not only blue states or red states, every state. And the people most affected, the ones whose rights just expanded the most dramatically, many of them still don't know what happened. Here's what went down. The Supreme Court issued a landmark ruling that destroyed the old system states used to deny gun permits to law-abiding citizens. The system where a government official could look at your application and say, "I don't think you need this. So, sir, you're A, and that was it. Denied. No gun, no real recourse, no rights. That system is gone, dead, unconstitutional. And what replaced it affects you directly. Whether you live in New York, California, Texas, Florida, or anywhere in between, most people hear Supreme Court ruling and think it's just academic talk for lawyers. It's not. What I'm about to break down is the difference between staying ahead of the curve and accidentally committing a felony because you didn't realize which rules changed and which ones stayed the same. I'm going to explain exactly what changed, what it means state by state, and what you need to do right now. Stay with me, because by the end of this, you're going to understand your gun rights better than 99% of Americans. Before I go any further, are you subscribed? Because what I'm about to explain is time sensitive. Gun laws are changing right now in real time in your state, and if you're not getting these updates, you could unknowingly break a law that didn't exist 6 months ago, or miss a right that just opened up for you. Hit that subscribe button right now and turn on all notifications. Okay, let's get into it. The case is called New York State Rifle and Pistol Association versus Bruin. Decided June 23, 2022 by the United States Supreme Court. It was a 6-3 decision. Justice Clarence Thomas wrote the majority opinion, and this case didn't just change the law for New York. It sent a legal shockwave through every state in the country that had ever tried to restrict who can carry a firearm in public. Here's the background. For over 100 years, several states operated under what's called a may-issue permitting system. May-issue means the government may issue you a permit if it feels like it. If some official behind a desk decides your reason is good enough, if they decide your life is dangerous enough, your neighborhood is bad enough, your job is risky enough, your circumstances are special enough, then maybe you get approved. New York had something called the Sullivan Law on the books for over a century. To get a concealed carry license, you had to prove proper cause. You couldn't just say you wanted to protect yourself and your family. You had to show a special need for self-defense that was greater than the general public's. You had to prove you were a target. You had to show documented threats. You had to convince a licensing officer, a person with total subjective discretion, that your life was valuable enough to warrant protection. California, New York, New Jersey, Maryland, Massachusetts, Hawaii, over 100 million Americans, nearly 1/3 of the entire country, lived under these systems, and for most of them, the answer was no. Your reason isn't good enough. Your fear isn't real enough. You're not important enough to protect yourself. That was the system, and the Supreme Court just burned it down. Let me paint you a picture of how this system actually worked in practice, because the legal language hides how degrading it really was. You're a law-abiding citizen, clean record, responsible adult. You want to carry a firearm to protect yourself and your family. So, you apply for a concealed carry permit. And then you sit across from a government bureaucrat who has never met you, never walked through your neighborhood, never looked over their shoulder in a parking garage at night the way you have. And they get to decide whether your fear is valid. They read your application. They look at your reason, and they say, general self-defense isn't enough. There are lots of people want to defend themselves. That doesn't make you special. Denied. Not because you're a criminal. Not because you failed a background check. Not because there's any evidence you'd be dangerous with a firearm. But because some official didn't think your reason was compelling enough to exercise a constitutional right. If you were a celebrity, Maybe you got a permit. If you were politically connected, probably. But if you were a regular citizen, a shopkeeper carrying cash, a night shift worker walking to your car alone, more often than not, the state said no. That is what May issue looked like. That is what 100 million Americans were living under. And that is exactly what the Supreme Court said is unconstitutional. So what did the court actually decide? Two men in New York applied for unrestricted concealed carry permits. Both wanted to carry for general self-defense. Both were law-abiding citizens. New York denied both of them. The state said general self-defense doesn't meet the proper cause standard. You need something more specific, a specific threat, a specific danger, something that makes you different from everyone else who wants to protect themselves. The STRI they sued. The case went all the way to the Supreme Court, and the court sided with them decisively. Justice Clarence Thomas wrote, "The majority opinion and the core holding is simple. The Second Amendment protects an individual's right to carry a handgun outside the home for self-defense. If you are a law-abiding citizen, the government cannot force you to prove a special reason to exercise that right." Think about what that means. Think about any other constitutional right. Can the government tell you that you can only speak freely if you prove your speech is important enough? Can they tell you that you can only practice your religion if you demonstrate a compelling spiritual need? Can they make you justify your Fourth Amendment rights before you're allowed to have them? No, because that's not how rights work. Rights are not privileges. They are not gifts the government hands out when it feels generous. You have them automatically. The government can regulate how you exercise them, but it cannot demand that you justify why you want them in the first place. That's what Thomas said. The Second Amendment is the reason you don't need another one. So, let me be completely clear about what this kills. May issue permitting systems are unconstitutional. If your state had one, it is gone. The proper cause standard in New York dead. The justifiable need standard in New Jersey dead. The good cause standard in California dead. Maryland, Massachusetts, Hawaii, all of their discretionary denial systems dead. What replaces them is something called shall issue. And the difference is everything. May issue. The state may give you a permit if it wants to shall issue. The state shall give you a permit if you meet the legal requirements. No more subjective judgment. No more bureaucratic gatekeeping. No more proving your fear is real enough by someone else's standards. If you're a law-abiding adult with no disqualifying criminal record, no relevant mental health history, and you meet your state's requirements, the state has to issue the permit. Period. They don't get to say no just because they feel like it. The state can still require background checks, fingerprinting, safety training courses, and application fees, but they cannot use subjective discretion. The era of the bureaucrat's whim is over. Now, here's something most people completely miss about Bruin, and it may actually be even more important than the permit ruling itself. Before Bruin, courts used something called intermediate scrutiny to evaluate gun laws. Under that framework, the government just had to show that a gun law was reasonably related to an important government interest. That's a fairly easy bar. The government just says, public safety cites some crime statistics and wins. Courts were rubber-stamping gun control laws under this standard for years, brewing through that framework out completely. The new test is what Thomas called the text, history, and tradition test. Now, when the government wants to defend a gun law, it has to prove that the law is consistent with the historical tradition of firearm regulation in the United States. It has to dig into the founding era laws from 1791, when the Second Amendment was ratified, and laws from 1868, when the 14th Amendment made the Second Amendment apply to the states. Think about how radical this is. If New York wants to ban you from carrying a gun in a park, it can't just say it's for safety. It has to go into the archives. It has to find a law from the late 1700s or 1800s that is a historical analog to the modern ban. If it can't find one, the law is unconstitutional. The Supreme Court is forcing the entire legal system to look at the Second Amendment through the eyes of the founders. If the founders wouldn't have recognized your law as a traditional restriction, then that law has no place in modern America. Assault weapon bans. Courts are asking whether laws banning specific types of firearms existed in 1791. Mostly, no magazine capacity limits. Same question. No clear founding-era analog waiting periods, specific licensing schemes, red flag laws. All of them are being challenged under the Bruin standard right now. Some will survive. Courts have found historical analogies for some modern restrictions. Others won't, and the ones that don't, they're getting struck down. Is the second revolution inside the Bruin decision? First May issue is dead. Second, the entire legal framework for analyzing gun laws just got dramatically harder for the government to navigate. Now, let's get specific because this hits differently depending on where you live. New York was the state at the center of this case, and it had the most dramatic response. Before Bruin, New York City issued concealed carry permits at a rate that was almost comically low. Regular people, business owners, single mothers, night shift workers, almost universally denied. After Bruin, New York had to scrap the proper cause requirement. It did, but then it turned around and passed the Concealed Carry Improvement Act within weeks, adding new sensitive location restrictions, mandatory training requirements, in-person interviews, character references, and social media checks. New York couldn't keep denying people for subjective reasons, so it made the process longer and harder. Gun rights groups immediately filed lawsuits. Courts have been reviewing those new restrictions ever since. Some have already been blocked by federal judges. The fight is ongoing, but the core right is established. California operated one of the most restrictive May-issue systems in the country. In many counties, especially urban ones, permits were essentially impossible to get for ordinary people. Post-Brew in California changed its standards. The good cause requirement is gone, but California, like New York, responded by expanding the list of places where carrying is prohibited: schools, government buildings, parks, public transit, bars, hospitals, stadiums, and many more. Some of those new restrictions are already being challenged in federal court. A number of them have been blocked by judges. The map in California is still shifting, but the default has flipped. New Jersey had something called justifiable need, and the standard was almost impossible to meet. So, there were years where the entire state of New Jersey issued only a few hundred permits for a population of millions. After Bruin, justifiable need is gone. New Jersey moved to a shell issue system. Applications surged immediately. The state was suddenly issuing thousands of permits to people who would have been automatically denied a year earlier. The fundamental change is real. You can now get a permit in New Jersey. That was essentially impossible before. Maryland required a good and substantial reason. Gone after Bruin, Maryland moved to Xiao. Applications increased dramatically. The process still exists. The requirement still exists. But denial, based on a subjective assessment of your need, is no longer legal. Massachusetts had a suitable person standard that gave local police chiefs enormous discretion. The result was wildly inconsistent. In some towns, permits flowed freely. In others, almost nobody got one. The outcome of your application depended almost entirely on which town you lived in and what the local chief's personal views on gun ownership happened to be. That discretionary system has been significantly constrained by Bruin. Hawaii was arguably the most restrictive May-issue state in the country. Hawaii also tried to claim geographic isolation as a reason for different rules. The courts rejected that argument. The Second Amendment does not have a Hawaii exception. Bruin applies everywhere. For people in Texas, Florida, and other already permissive states, Bruin matters to you too. First, it locked in the shell issue standard constitutionally. States can't slide back into Maya's issue systems. The right you have right now is constitutionally protected against erosion. Second, the new historical test applies in your state, too. Laws that were questionable before are now being challenged under the stricter Bruin standard that benefits gun owners everywhere. Let me make this real with 3 scenarios, because legal theory means nothing until you see how it changes actual lives. You work nights at a hospital in a part of Los Angeles that makes you nervous. You walk to your car at 2 a.m. in a parking structure. You've been followed twice. You called the police. Nothing happened. You want to carry a firearm to protect yourself walking to and from your car under the old California system. You apply for a permit. You explain your situation. The county sheriff reviews your application. They say 2 incidents in a parking lot aren't enough. Lots of people work nights. Lots of people feel unsafe. That doesn't make you special. Denied. Under Brew. You apply. You're a law-abiding adult. You complete the required training. You pass the background check. The county has to issue the permit. Your reason is self-defense. That is the reason the Second Amendment was written. The county doesn't get to override the Constitution because it decided your fear isn't compelling enough. You get the permit. You own a small convenience store in Newark, New Jersey. You've been robbed twice in 3 years. You've had employees threatened at gunpoint. You want to carry a firearm when you close up at night and walk to your car under the old New Jersey system. Justifiable need. You have documented robberies. You have police reports. You have more justification than most people will ever have. But the discretionary standard still means a bureaucrat has to decide your need is justifiable enough. And maybe they decide it's not specific enough. Maybe they decide you should just hire security. Denied. Under Bruin, justifiable need doesn't exist anymore. You apply. You meet the requirements. You get the permit. The state does not get to decide that your documented history of violent crime at your own business isn't a good enough reason to exercise a constitutional right. You live in Hawaii. You have 3 kids. You want to carry a firearm to protect your family. Not because you've been threatened, not because you have a dangerous job, because you believe in being prepared, because you believe the Constitution gives you the right to protect yourself and your children. Under the old Hawaiian system, denied before you finish submitting the application. Hawaii almost never issued permits to civilians. Under Brew, you apply, you complete your training, you pass your background check, you meet the requirements. Hawaii has to issue the permit. The Second Amendment exists in Hawaii the same way it exists in every other state in this country. The ocean doesn't change the Constitution. These aren't hypotheticals existing only in legal briefs. After Bruin dropped, permit applications surged in every former May-issue state. States that issued hundreds of permits per year started issuing thousands because the law changed, because rights expanded, because the Supreme Court said what should have been obvious all along. The Second Amendment applies to you. Now, here's where it gets dangerous for gun owners, if you're not paying attention. Because the states aren't taking this line down, since they can no longer deny you a permit based on subjective reasons. Restrictive states are now trying to make the permit useless. Immediately after the Bruin decision, states like New York and California started passing emergency legislation. They began designating almost every square inch of public life as a sensitive place, park-sensitive place, public transport-sensitive place, bars and restaurant-sensitive place. Any private business that doesn't have a sign specifically saying, "Guns Welcome Potential Felony Zone." They are trying to create a patchwork of laws where you can legally carry your gun. But the moment you step onto a sidewalk or walk into a coffee shop, you become a criminal. Some jurisdictions also expanded character requirements as a backdoor to reinstate subjective denial. They now require social media audits. They want to see your Facebook and Instagram posts from the last 3 to 5 years to look for red flags, in-person interviews, broad mental health record waivers. If a licensing officer doesn't like a political meme you shared 4 years ago, can they deny your permit based on character? Gun rights groups are already back in court, arguing that these character requirements are just proper cause, wearing a mask. And remember the historical test. If New York can't find a law from 1791 that banned firearms in public squares, then its modern ban on carrying in Times Square is on very shaky legal ground. Let me bust 3 myths that are spreading fast because getting these wrong could get you arrested. Myth 1. Bruin means you can carry without a permit. Absolutely not. The Supreme Court did not rule that permitless carry is constitutionally required everywhere. It ruled that MIAS issue permitting systems are unconstitutional. The difference is enormous. If your state requires a permit to carry, and most states still do, you still need to get one. Brewing changed. Who can be denied? Not whether permits are required. Do not start carrying without a permit. Just because you read something online about brewing, read your state's laws, follow the process, get the permit. Myth 2. Gun-free zones are all unconstitutional after brewing. Also, wrong. The Supreme Court explicitly acknowledged that states can designate sensitive places where carrying is prohibited, and it mentioned schools and government buildings as traditional examples. States responded to Bruin by dramatically expanding their list. Some of those new expansions are being challenged in court, and some have been blocked by judges, but many are still in effect. If your state says you can't carry somewhere, you cannot carry there. Regardless of what Bruin says, you could still be arrested. Know your state-sensitive place list before you carry anywhere new. Myth 3. Background checks and training requirements are gone. Wrong. Justice Kavanaugh's concurring opinion made it very clear states can still require background checks, fingerprinting, and safety training. The court isn't saying the government can't vet you, it's saying the government can't ignore you. If you're a law-abiding citizen, you still have to play the game just by the new fairer rules. Step back for a moment because brain isn't an isolated decision. It's the third movement in a deliberate progression that has been building for over 15 years. District of Columbia versus Heller. In 2008, the Supreme Court ruled that the Second Amendment protects an individual right to own a firearm for self-defense in the home. Before Heller, some courts argued the Second Amendment only applied to organized militias. Heller said, no, it's an individual right. McDonald versus City of Chicago. In 2010, the Supreme Court ruled that the right established in Heller applies to state and local governments, not just the federal government. That matters because almost all gun laws are state and local. New York State Rifle and Pistol Association versus Bruin. In 2022, the Supreme Court extended the right outside the home into public spaces and established the historical test that makes it dramatically harder for any government to restrict that right. Each case builds on the last. The right started at home, then it was protected from state interference. Now it exists in public. The direction of travel is unmistakable, and it is not stopping. To understand where you stand right now, the American landscape for gun owners has split into 3 distinct zones. You need to know which zone you're in. Zone 1 is the freedom states. Places like Florida, Texas, Tennessee, and over 25 others that don't require a permit at all for law-abiding citizens. In these states, Bruin didn't change the day-to-day reality much, but it did provide a constitutional shield that prevents future legislators from rolling back those rights. What you have is now locked in. Zone 2 is the compliant states, places like Ohio, Pennsylvania, and Virginia that have been shall for a long time. These states already had objective standards. Bruin's simply reinforces their system as the national constitutional baseline. Zone 3 is the battleground states, New York, California, New Jersey, Maryland, Hawaii, and Massachusetts. These states are in a state of legal civil war. The laws are changing weekly. One day a judge strikes down the social media check requirement, and the next day an appeals court puts that ruling on hold. If you live in one of these states, you cannot afford to be casual about your carry habits. You must check your local laws regularly. Join a state-level gun rights organization. They are the ones filing the lawsuits, and they will alert you the moment something changes. Let me bring this home, because this isn't just about legal theory. This is about something that matters at a fundamental human level. Self-defense is the most basic right a person has. Before any government, before any constitution, before any law, the right to protect your own life. And for over 100 years in states across this country, the government took that right and turned it into a privilege. They said, you can protect yourself if we decide you deserve to. You can exercise this right if you can convince us your fear is real. Your life is worth protecting, but only if we agree. Think about who that system hurt the most. It wasn't people with connections. It wasn't people who knew the right officials or had the right last name or lived in the right neighborhood. Those people got their permits. The system worked fine for them. It was ordinary people, working class people, people in high crime neighborhoods who needed protection most and could access at least single women in cities where permits were essentially impossible to obtain. Small business owners who couldn't afford private security. Night shift workers walking to their cars alone, the people who were most vulnerable, the system most consistently denied them. Bruin said, that has to stop. The Second Amendment doesn't have a rich person exception. It doesn't have a politically connected exception. It doesn't evaporate in urban areas because officials there are uncomfortable with it. It applies to everyone everywhere equally. Your life doesn't need to be important enough by some bureaucrat standards. It's important. Period. And the Constitution agrees. Before we close, here are 3 rules that will keep you on the right side of the law while you exercise your expanded rights. Rule 1. Ignorance is a felony. In the pre-Brew world, you knew the answer was always no. In the post-Bruin world, the answer is yes. But you must check your local and state laws consistently. Join a gun rights organization. They are filing the lawsuits, and they will email you the second the law changes. Rule 2. This is a marathon, not a sprint. The Supreme Court set the foundation, but the house is still being built. It took 100 red years to build the Mayo Wall. It's going to take more than a few months to tear it all down. Be patient with the process. The fact that you can apply and eventually must be approved is a victory that previous generations of gun owners simply didn't have. Rule 3. Your rights are only as strong as your voice. The Supreme Court can give you a right, but politicians can make it so expensive and socially complicated that you're afraid to use it. Bruin gave us the legal win, but the cultural win is up to